very happy Wednesday to you and welcome to our Elville webinar series. In today's webinar, you'll learn what elder law attorneys are advising clients in 2024. And your presenter is our very own managing principal and lead attorney, Stephen Elville. And my name is Jeff Stauffer, Community Relations Director with the firm, and I'll be your moderator. So a few housekeeping items as we have some new attendees on here today. We encourage your general questions throughout, so please note them in the questions panel or the chat, and we'll pause periodically to address your questions. And your questions add a lot of value, so don't be shy in posing those questions at any time. Yesterday by email, you also received the presentation slides that Steve will be referencing. If you didn't receive that for some reason, or you may have registered late yesterday or this morning, they're available in the section marked handouts in the panel on your screen to download at this time. We also have some professionals on today's presentation. Welcome to you as well. Most everyone may receive 1.5 continuing education hours for attending. So if I don't have your accreditation or board ID number, please send that over to me if you'd like to receive your CE credit. Everyone will also receive a post-webinar feedback email right after the presentation. Please take just a couple minutes to fill out this really simple and brief survey and share your thoughts about today's presentation. We value your feedback very much. I have a question for you. Have you achieved your planning goals, or have they shifted since you last looked at your planning? If not, or if this is the case, consider a consultation with us, whether it's starting from the beginning, older documents that may need to be addressed, an administration matter, or any other planning. Steve and our team are here to advise you and counsel you every step of the way. I'd like to offer Steve and the firm just a brief introduction, then we're going to jump right in. I know you want to hear from Steve, so you should be able to see my screen here. We're Elville & Associates, been around since 2010 in Columbia, founded by Stephen Elville. We have several different practice areas that we focus on here at the firm, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, and tax planning and asset protection, which does fall into the elder law and estate planning context. We have 9 attorneys, 12 staff members, and 3 locations, including our brand new Rockville location off of Rockville Pike, which is going great. Hope you'll go down there and see us if you're around there. Our mission, as it always been, has been, and always will be, is to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. And we focus on education a lot here at the firm. It's really important. We do that in several different ways. A few of them are through our planning processes with our clients. We have different programs to suit all families and individuals here at the firm. Also, we have many educational webinars and workshops in the communities that we serve each year, and also by way of our accredited client care program, one of only just a couple firms here at Elville & Associates to have a client care program accredited by the Client Care Academy in Boston. We also focus and work on the ideals of client education, collaboration, and compassion in mind every day with every client here at Elville & Associates. And just a bit about Steve. His work as an attorney for 20 plus years, 24 I think to be exact, Steve, has been centered in elder law, special needs planning, and estate planning, and emphasis in the areas of tax planning and asset protection. A member of many different national membership and professional organizations, including, just to name a few, the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys. Steve works to offer peace of mind to clients by creating solutions to their needs through counseling, the use of client education, and the use of leading edge legal technical knowledge. Steve is a very seasoned presenter. If you haven't heard him speak before, each year offering many webinars, workshops from businesses and their employees, presenting at different conferences throughout the area, and continuing education events. And Steve, lastly, was named to the Maryland Super Lawyers list for a 9th time and 8th consecutive year in 2024. So congratulations there, Steve, and we'll see what 2025 has in store soon. Steve also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization Steve founded in 2014. I'm very fortunate to be part of. If you'd like to learn what we do each day to make a musical difference in the lives of children, please reach out to me. I'd be very happy to share our story with you. If I could turn my computer around, you'd see probably about 25 instruments that I'm getting ready to deliver to some area schools, and that's just one thing that we do at the Elville Center. So Steve, I'm going to turn it over to you and make you the presenter.
Thank you for that wonderful introduction, Jeff.
My pleasure.
I'm going to show my screen and get the presentation going, and then you can tell me if I am doing it correctly.
That looks great, Steve.
Very good. Thank you so much, Jeff. And good morning, everyone. And it's another beautiful weather day here in Columbia, Maryland. Happy Wednesday to you. And Jeff, I just have to say, I don't know what you're doing to continue this wonderful weather, but thank you. And
it's my pleasure.
And hey, I'm enjoying every bit of it. And I know we're going to need rain later, as we get into the fall. But hey, I'm enjoying these wonderful, beautiful days. And for everybody who's in attendance, our regular attendees, for those of you who have joined us before, our special guests, our collaborative partners, financial advisors, CPAs, and other professionals, welcome. And I know your time is very valuable on this Wednesday. I'm going to take just a minute here to recognize something that's pretty obvious. We are having this webinar on the morning of the anniversary of September 11th, the September 11th catastrophe. And I just want to take a minute here to maybe a minute of silence to really get started here in the right way on September 11th. I'm going to time it, and let's just take a moment to think about those who passed away and our servicemen and women who continue to protect us in the aftermath of the terrorist attack. Thank you very much for taking that time as we get started here in the right way. We're going to take another moment here in just a minute to kind of gather our thoughts about this material we're getting ready to go into about elder law. But again, I welcome everyone today. We're going to begin on time here and we're going to end on time. We know your time is very valuable. And as I thought about this particular presentation, which we've given many times before, what in the world is happening here in 2024 in elder law? Well, as I thought about this, I said to myself, well, elder law has really become, in my mind, a subjective question, like what is elder law? And what is elder law to you? What is elder law to this particular family or this particular individual? And I think we need to take just a few minutes to explore that. And where I'm really going here as we get started is the juxtaposition between estate planning and elder law, and the juxtaposition of the different types of focuses in elder law as those in attendance get to know or get their minds around what elder law really is, not only what attorneys are talking to people about, but what is it? So for example, our client event that's coming up in November, we are having arguably maybe the most prolific elder law attorney in the country, who is now retired, Jason Frank, who wrote the book on elder law in Maryland. He is going to be our featured speaker at our client event coming up. So we think so much of what is happening in the world of elder law that we're going to spend an entire client event talking about the kind of traditional notions of elder law versus the juxtaposition, that's the word I keep using, of how estate planning and elder law kind of cross over. And is elder law really a subset of estate planning itself and vice versa? So as we think about this, I want to kind of throw out some ideas. Elder law can be viewed as a very narrow set of parameters. For example, we could define elder law very narrowly as disability planning or nursing home placement or Medicaid, which is called medical assistance in Maryland. Understanding those types of concepts and getting people approved for those kinds of programs and understanding the underlying law in the Medicaid law, which is no small thing. Or we could define elder law as encompassing guardianship. And you see now we're starting to get a little bit broader, guardianship and Social Security and housing, okay? All of those things. And now disability planning, having to do with powers of attorney and advanced directives. But now we start to meld into areas of estate planning and income tax planning. You know, yes, income tax is a big issue in estate planning as it kind of melds into elder law. And then we have clients who are what we might call traditional estate planning clients who come in to do routine estate planning. And then what happens inevitably is there are questions about aging, questions about continuing care retirement communities, questions about assisted living, questions about how to preserve assets in the elder law or elder care context, where we are dealing with long-term care and long-term care costs and insurance. So my point here this morning is to really kind of lay the groundwork that elder law is very, very hard to get our minds and our arms around. And estate planning and elder law do meet, and they do cross over into other areas. So as long as we have that in our frame of thinking here this morning, I think we're on the right track. I want to take another minute. I know I'm very deliberate. I want to take another minute, which I'm going to hit the timer right now. For those in attendance who are non-professional attendees, people who are not collaborative financial advisors or CPAs, to just ask yourself, as we get grounded into the information, what am I here for? Am I here to learn about long-term care projection of my planning, that particular element of it? Am I here about preserving assets? Am I here to understand how powers of attorney work? Am I here because I have an aging loved one or someone who is disabled or is ill or, God forbid, terminally ill? What are you here this morning for? Let's just take a few seconds as you have your pad, your tablet, your phone, whatever it is that you are using. I strongly encourage you to write down your thoughts before we get started so you get the most out of this as we try to give you something substantive to take away. Just a few more seconds. We want to be intentional. And again, I thank you as we get started for your commitment to education, your commitment to learning. That's what we believe in here at Elville and Associates. And again, I salute you for that commitment. Okay, we're going to get started after that kind of preliminary introduction. And of course, today we are not talking about legal advice. We cannot render legal advice by way of a webinar, but we are giving very macro level, very high level education, which we hope you may or may someday need to enter into an attorney-client relationship with us. If you need assistance, we are here to do that, or to collaborate with our financial advisor and CPA and life insurance professionals that may be on this, or other professionals on this webinar. So today, having set the background of what is really going on in the broader sense of elder law and how it could be considered a subset or vice versa of estate planning, we're going to talk about trends in Maryland. We're going to talk about federal law and the Affordable Care Act. We're going to talk about problems that we're dealing with. We're going to talk about supported decision making. We're going to talk about elder abuse, the costs of care. We're going to talk about how to think in terms of asset preservation. Very, very broad subject matter. But before I continue any further, and I know I'm taking a lot of time here at the beginning, I just want to back up just a second and pose this concept that perhaps what we're really talking about when we're talking about the elder care side of estate planning, or the estate planning side of elder care, however we want to look at it, but especially the first one, the elder care side of estate planning. And remember that elder law, in my mind, is nothing more than an extension of estate planning to address disability, housing, Social Security, special needs planning, Medicaid, nursing home placement, and all of those things that we've talked about previously in the webinar so far. So when we're talking about elder law, what is the purpose, the real purpose of this information? It's really, when you think about it, to ease suffering. And this may seem like a foreign concept to someone who's maybe just joining us for the first time. But I've seen as an elder law attorney so much suffering, and many of you are healthcare workers and maybe even some aging life care managers on this webinar. And I'm not really talking about the obvious suffering of aging and people with dementia and other problems as we age. I'm really talking about the psychological suffering of being uninformed. What we're really talking about here is getting a groundwork, a frame of reference to try to take this very ambiguous concept of elder law and get our arms around it. Because to whatever degree that you can do that, to whatever degree you can do that for a loved one and extend this information out to a loved one, you are going to ease their suffering. Because our loved ones who are dealing with these long-term care issues, or spouses that have a progressive illness, not to mention people who lose their loved ones, but while those loved ones are still alive and incapacitated or becoming incapacitated, and all of these issues are building up, whether they are crisis issues, especially, or whether they are pre-crisis issues, you have and I have an opportunity to ease their suffering. I'll give you a very quick example. So it would not have been uncommon for me a few years ago when I was a younger lawyer and still traveling out of the office, which I still do on many appointments, but fortunately we have about 9 attorneys total here with 22 employees and several offices. I don't have to do that all myself at this point. But it would not be uncommon for me to meet someone at a home, or meet someone at a facility, or meet someone at a restaurant who was a spouse in crisis. And just to give you an idea, and you've seen this yourselves, hope maybe, possibly, that spouse might be suffering from, first of all, exhaustion. Second of all, taking care of a spouse who is disabled, not having any help or having spotty help, and also being unfortunately very, very drastically uninformed, or the information they have received is inaccurate. Information that says you are going to lose your home, your long-term home. You're going to lose all of your assets. You're going to lose all of your retirement assets. You are going to be destitute. And if you don't do this nursing home placement correctly, very, very bad things are going to happen. Or your spouse will not be able to get properly placed. Not to mention all of the level of care issues, all of the actual care issues in the home or in an assisted living through the progression of the continuum of care. So it would not be unusual for me to see this over and over again, the suffering and the pain that goes along with the actual loss of a spouse due to dementia, Parkinson's, other long-term illnesses. So what we're really talking about here is getting informed, being educated, and learning that many of these concepts that are trickling down to people who are dealing with these issues are really myths. They are incorrect, they're lies, they're mistruths, they're inaccurate, and we can solve a lot of suffering and a lot of problems through education. All right, now having said all of that, why are people coming to see elder law attorneys? Well, first of all, as I mentioned earlier, it could be that it's just a part of estate planning. Estate planning and an educational approach to estate planning lends itself to questions that raise other questions that kind of lead into counseling. And so one of the things that we're proud of here at Elville and Associates is that we're counselors. And I think attorneys, as well as other collaborative professionals, may pride themselves in being counselors and not just technicians. So first of all, clients come to see elder law attorneys by way of estate planning. They come because of age-related issues, obviously. But they also come for pre-crisis planning. Many people are driven to try to preserve assets for long-term care purposes, and we're going to call that long-term care asset protection, as opposed to general asset protection, or the kind of lifetime asset protection we might have in IRAs or life insurance. But this is a type of asset protection we're going to call elder care or long-term care asset protection. There's been a change of circumstances. God forbid someone has suffered a stroke or some kind of a catastrophic event. That obviously causes a crisis. And so there's crisis planning in elder law, and there's pre-crisis planning, okay? Parents that are dealing with issues. parents of our parents, meaning our grandparents, disabled children, people who are having issues with disabled children or loved ones of all kinds, of all different levels of disability. Do they have the proper programs? Do they need a guardianship? And so on and so forth. And other loved ones with elder care related issues. So we're dealing with healthcare decision making in Maryland, and I would strongly encourage you, not just if you're bored on a winter's day, but I strongly encourage you to take a look at your advance directive. Take a look at the advance medical directive of a loved one that is someone you care about. Look at these documents with them and make sure they're updated. Look at the Attorney General's website, the marylandattorneygeneral.gov. Go on that website and look at healthcare decision-making policy in Maryland. Look at the MOLST law, M-O-L-S-T, medical order for life-sustaining treatment. Get informed. Financial decision-making, okay? Who are the fiduciaries? This is obviously one of the biggest issues in planning today. Who is going to be my agent? Who is going to be my healthcare agent? Who is going to be my personal representative under my will? Who's going to be my trustee under my revocable trust or testamentary trust or special needs trust, life insurance trust, on and on. In-home care, we have a proliferation of in-home care. Are those care providers licensed? Are they insured? Making sure that we're buttoning up all these issues. Is proper income tax withholding being done? Nursing home placement, obviously a huge issue. And one of the big issues we see is someone being placed from a hospital. Many of you have dealt with this, and this will resonate with many of you. Your loved one is in the facility, let's say a hospital, excuse me, and that hospital now is ready to discharge. There is a tension point right there. There is some tension, and the issue is the discharge appropriate? Is there an agreeable place where the person will be discharged, such as a rehabilitation center? Is discharge back home appropriate? This is one of the trigger points in elder law. Be aware that if you're a healthcare agent, you have a lot of power to control that situation. No matter what the hospital is saying, this is an elder law issue that everyone needs to be aware of. If you're a healthcare agent, you have a lot of power and you can exercise that power within reason, and you should be advised at a time like that. Assisted living placement. We want to make sure we're looking at contracts and so forth for these types of places and make sure that care plans are being provided. Estate planning, we talked about this. Good estate planning is not only what happens at death, and there's lots of things that can be done if there are spouses that are ill. We're departing from traditional estate planning. Powers of attorney, advance directives, not only what happens at death, but what happens during life. I mentioned asset protection earlier. Understanding and limiting liability when we have caregivers coming in our home, or fiduciaries such as agents under powers of attorney. What is my limit of liability? How do I handle paying my loved one's bills? And what are the limits of my responsibilities? Very important issues. Assisted living contracts, nursing home contracts, continuing care retirement communities, such as the Asbury Methodist Village in Gaithersburg, or Riderwood in Silver Spring, or Charlestown in Baltimore. And of course, medical assistance. So the Medicaid manual is quite shocking. It's about 2 feet thick if we were to print it out. It is fortunately online, and so there are various types of Medicaid or medical assistance. And Maryland is an expanded Medicaid state. It's important to understand the parameters of Medicaid in the elder law context. Medicare, surprisingly, elder law attorneys don't many times deal with Medicare, in my experience, but there are resources to be able to deal with Medicare, and Medicare obviously is a very important benefit. And I'm going to go now to the next slide. So as we kind of laid the groundwork for, what happens in people's lives, what happens in the continuum of not only care, but the continuum of planning. For example, most people don't have any planning, 55 to 60% of people. So that's where we have to start. we have to start with the foundational idea that we have to have a basic estate plan in place. What happens at death? What happens during life? We're going to get into that more. But as we kind of take in this overwhelming information about, aging, all of these issues, the cost of care, all of these things, how do we best kind of solve this problem, or at least start to solve this problem of easing suffering, educating people so that they are armed with information and can make informed decisions? They can make informed decisions. Well, in the world of elder law, this starts with an elder law consultation. I was just meeting with a young mentee attorney in the last couple of days, and this attorney, I think, is going to go do great things in elder law in the future to help a lot of people. And one of my strongest and first pieces of advice to her was to learn how to do a proper elder law consultation. So what is this elder law consultation all about? And I wish that I could take credit for this, but I have been mentored myself for many years by some of the giants of elder law in Maryland, such as Jason Frank and others. So I have to give credit to them to have groomed me in their own way to know this information and to be able to share it with others. So if you or someone you know is kind of suffering from a lack of information, or suffering from anxiety or stress and nervousness over this whole issue of uncertainty about the future, when it comes to elder care issues, the elder law consultation is the foundation for change. Okay, what is it? Well, it's a lot of fact finding. It takes about an hour and a half to 2 hours in my experience. There's an identification of problems. Goals. Goals are always the first step, whether it's estate planning, financial planning, elder care planning, whatever it may be. Goal-driven ideas, okay? Looking at incapacity and how does it work? What are the powers of the agent, and how should the agent really look at exercising those powers? An overview of long-term care issues, medical assistance, asset protection. You notice I'm being redundant on purpose. The cost of care and how financing a long-term care actually happens. Sometimes with long-term care insurance, many times with no long-term care insurance. And how does this all relate to Maryland? A discussion of the advisory team. Many of you on this webinar have noticed I've mentioned this several times already. What if we have our financial advisor friends, collaborative partners such as CPAs and others on this webinar? That's because it's very important as you go towards, eliminating stress, eliminating suffering through education. You also are armed with the resources. Hopefully you do have a financial advisor with resources that can help you. Hopefully you do have a CPA or a tax person who can help you, and an elder care attorney / estate planning attorney or life insurance professional. And I'm going to add to this team of collaborative advisors an aging life care manager. There are many good aging life care managers, such as Ellen Platt of the Option Group, Allison Stanton, Jill Rossner, and others. These people are giants, as far as I'm concerned, in helping people like us, people like me, to be able to do what we do, to help clients and do assessments and to manage caregivers and to do level of care determinations about placement, okay? But perhaps most important from the elder law consultation is not just information for the sake of educating, but recommendations about next steps. So one of the things I observed as a young lawyer was that many of our elder law associates or colleagues, I didn't think were that proactive. I think they were very knowledgeable, and I use the word giants in their field. But what I've decided over the years is that what clients really need and want, and what families really need and want, and individuals, are recommendations and next steps, not only to clarify the fog and the ambiguity and the confusion, but to help formulate next steps. So this is the basis for change. This is the elder law consultation that I want you to take away today as the next step for those who need this clarification and education and next steps. So as I mentioned, it serves as a basis for a shift in planning. It could be, we were talking about routine planning, now we're talking about elder care planning. And how does that resolve itself? How does that transition? It resolves ambiguities and misconceptions. It relieves anxiety and hopelessness. That's a powerful word. It gives a new sense of direction for people that have to move forward, people that have to support not only themselves, but the person with a disability or an incapacity. It provides a sense of empowerment. Now, does that mean we always have earth-shattering solutions? The answer is no. But the basis for education, or the educational foundation, I think itself does give a sense of direction and empowerment regardless of the strength of the recommendations in some circumstances. For example, we could argue that Maryland is one of the poorer places, or one of the worst places in the country to age. I'm sorry to say that. But one of the issues in elder care is that we as elder law attorneys and advisors, we have to be aware or cognizant of the fact that jurisdictional issues now apply. For example, where we have someone who could age in place in Delaware versus Maryland, well, not only may someone prefer Delaware because it has beaches, and so do we, of course, but Delaware law many times is more favorable for aging in place and access to Medicaid waiver programs and so forth. Even though I'm not a Delaware-based attorney, we work with Delaware lawyers. New York, for example, has very robust Medicaid programs that provide, benefits that are far beyond what one can achieve in Maryland if they are a resident of Maryland. So again, this is not something that we always are going to have earth-shattering results, but again, the sense of empowerment, the sense of direction, and the knowledge of the choices that are available, this is the foundation. Now, if you're blessed, your family is a unified family, and if it's not, this is an opportunity to really address the weaknesses in that structure, and where can we bring in professionals to help with those weaknesses. Now, last thing I may say on this slide is that the financial wherewithal of a particular person may not be as strong as the financial wherewithal of another person. So that is something that we have to deal with. How are we going to get from point A to point B, not only with advisors and not only with a sense of empowerment and a sense of direction, but financially, how are we going to get there, and what makes the best sense, keeping in mind that various jurisdictions may be more favorable than Maryland, and sometimes that is realistic for people and sometimes that is not. So I mentioned asset protection. Jeff, we're about halfway through the presentation, and I just want to make sure that everybody knows they can ask questions, they can interrupt me. You'll know how to do that, Jeff, as the great professional that you are, but I'm just going to continue until I hear from you further. So asset protection is something that is fundamental to elder law. But let's put in context what asset protection is. There are many types of asset protection, but I'm just going to kind of get our minds around three major ones. There's the kind of asset protection during your life. Now, as you see from the quotations or the parenthesis here, this is not at the forefront of elder care concerns, but it is not unimportant. This is an important thing. Husband and wife protection, spousal protection, wife-husband. This is protection where you can own property or a brokerage account as tenants by the entireties and have a fundamental form of asset protection. This is something that we want to know as we're looking at our fundamental estate planning. Life insurance is protected from the claims of creditors generally if your spouse or child is the beneficiary. That includes cash value and death proceeds. Annuities are the same. Qualified plans, 401ks, 457s, 403bs, and IRAs are protected from the claims of creditors, but not when we leave those IRAs to our loved ones. They are not protected from creditors as long as we leave them outright. So if we have to use a trust, if we're going to protect those assets. And then domestic asset protection trusts, like domestic asset protection states like Delaware, Alaska, Nevada. This is beyond the scope of today's discussion, but this slide is really to kind of put in your mind that there is the kind of asset protection we enjoy every day in certain types of assets that are titled certain types of ways as well. Now, in the long-term care or elder care context, we might look at it differently. We use different tools to achieve asset protection. So some people are motivated by pre-crisis planning. We're going to put all our assets or put a lot of assets or certain assets into a Medicaid trust. We might call this a 5-year trust or a Medicaid asset protection trust. This is arguably the most powerful tool in planning today for many uses, not just necessarily for Medicaid planning. This is a hybrid, irrevocable trust. A veterans trust is a tool for someone who is going to be on benefits from the VA, and the VA has many pensions. This has to do with the aid and attendance benefit pension, and this is a tax-free income. We use a trust to sometimes accelerate the eligibility for someone to get that benefit, and at the same time do some long-term care planning for Medicaid as well at the same time. The use of trusts under wills. This is a strategy that has been around since 1993. Maryland has put its seal of approval on this method, even more so in recent years, which is beyond the scope of this discussion. So this is about how spouses who are dealing with a long-term illness can use these types of strategies for the greatest benefit of the family. The augmented estate, which again is beyond the scope of this discussion, is really related to Maryland's seal of approval of the use of the well spouse being able to leave a trust for the ill spouse. Should the well spouse die first? This sometimes happens, God forbid, not always, but in that situation, that sad situation, there can be some powerful asset preservation, which would be the subject of a different discussion in person. The 5-year period, or what we call the 5-year look period, has been around since the Deficit Reduction Act of 2006. And so this is the idea of divestment of assets 5 years in advance, where we're divesting assets away from ourselves and starting that 5-year period of having divested the assets. This helps us preserve assets for those who are strongly motivated to do that. Where we have no pre-crisis planning, but we have the proper foundation of incapacity planning. These are the powers of attorney. Where we have that proper foundation, it is possible under the current law to save 50% of the assets roughly, more or less, and still achieve a long-term care skilled nursing Medicaid approval. So the rule of halves says we can approximately save 50% of the remaining assets, not counting taxes if we have to cash out an IRA, not counting other, miscellaneous costs, but roughly this is a way, even if we've done no pre-crisis planning, that we can save some of the assets with proper foundational planning. Life estate deeds. This is a method, a simple method of being able to preserve a piece of real estate. I live in a house. I transfer that house to myself for life, but I not only transfer it to myself for life, I give up the power to sell the property. Medicaid says if I give up that power to sell, I have just given away the property to my remainder men, which might be my children. So that starts the 5-year period. So that's a simple way of preserving real estate from a long-term care situation if we're successful with the 5 years. But it's also very simple, and it may be an irrevocable transfer of assets that is not appropriate for someone who wants to retain a little bit more control, for example, through the use of a trust.
Steve, can we pause for a couple of questions?
Yes, please do, and I'll take a drink of water.
Thank you. Our first question is, once a person activates their durable power of attorney, can their agent take action to establish a Medicaid protection trust to protect, looks like, money for shares?
Yes, so if I understand that question correctly, what I'm going to say, Jeff, is that if that power of attorney, because remember we just talked about the foundational planning, if that power of attorney is robust enough and allows for the creation of an irrevocable trust and the funding of an irrevocable trust, right? That is the key. Then an agent can actually establish a Medicaid trust. And that's a wonderful question. But the thing to take away from that question above and beyond my answer is that the average person is not going to believe this, but powers of attorney come in different varieties. They sometimes are plain vanilla, sometimes they are old, sometimes they are robust and have all of these nice advanced powers. And that's going to depend on the kind of counseling the person was given at the time of execution of the power of attorney, but it's also going to depend on the desires of that person. Did they want to extend all these powers, assuming they were properly advised? So again, without that flexibility in that financial power of attorney, such a thing would not have been possible, which is the agent signing a trust, which, remember, a trust is a fancy contract if you want to look at it like that. And so an agent can sign a trust and fund a trust, but an agent could not sign a will. Thank you for that great question.
Okay, and one more briefly. You mentioned a website for keeping up on state and federal law changes. Can you mention that one more time for us?
Yes, I would mention two websites. I think the initial one I was mentioning was really just the marylandattorneygeneral.gov. I think that one has got some public policy things that are kind of neat to know about. But the healthcare, Maryland healthcare law, right? That's what I'm really trying to convey there. But of course, there's consumer law and there's other things in there. The other thing, Jeff, I think we'll throw out here is Elder Law Answers. Elder Law Answers is a wonderful website, elderlawanswers.com, I think. And this is run by our longtime friend to the elder law community, Harry Margolis out of New England. And this is an interesting website that has many, many pieces of information about lots of elder law issues, Elder Law Answers.
Great, thank you, Steve.
Thank you, Jeff. Okay, so it's quickly approaching 11 o'clock, so I'm going to keep going here. So what are people coming in to learn about? Well, the questions. How can I pay for the cost of assisted living? Now, if you've got your pad or your tablet or your phone, you may have your own questions. Will I lose my home? Well, with proper planning, the answer is generally absolutely not, generally. Will I survive in the community? How am I going to do that? How am I going to, if I'm a spouse and I've been married for 50 years, how am I going to survive? Can we preserve our assets? What do I do in general? What are the parameters of things that I should be thinking about? How do I deal with placement? Now, the good news to many of these questions is that we've got absolute answers of how to think about these things and be educated. Healthcare decision making, we just talked about that. Get educated. Look at the Moles Law. Look at your advanced directive. Look at Maryland healthcare decision making. Okay. Will I need a guardianship of my loved one? This could apply in special needs. It could apply in elder care. Can I get veterans benefits? Well, in 2018, the VA rules changed. How should my assets be titled? If I have an aging or disabled spouse that is now have a progressive illness, but I want to do asset protection, should the assets be titled in my name? And it's not, and meaning I'm the well spouse. Well, there's lots of yeses to that answer in many cases, but certainly not for retirement plans or other assets that would trigger tax if someone were to transfer the title. So we have to look at this on a case-by-case basis. How do I deal with caring for my impaired loved one? And I'm already exhausted, and I'm already breaking down physically. Well, thank goodness there is a aging life care manager or caregiver community that many, many resources that many of you are aware already that are available. How can I live in a CCRC, and a continuing care retirement community? Should I move there? Would that preserve some of our assets? And can we get VA benefits and so forth? These are the questions that are being asked. So clients come in and they are asking these questions, and many of them are organic, many of them are hypothetical. Kudos to those who are thinking in advance like you. So changes to estate planning. These are hard things. We have an estate plan in place. We were very diligent, but now due to aging and due to level of care issues and due to financial planning issues and asset protection issues, this plan needs to maybe merge into a different type of estate plan that is more focused on elder care. And for those of you who are curious, this could be someone that, it's not just for the person who has an estate of $500,000 or less. This could be a person that has a total estate of $1 million to $3 million to $4 million or more. So these issues touch many, many people and are not just for people who have minimal assets. Placement. Should I transfer assets? Levels of care. How do I deal with this? Okay, we're going to take 1 minute on this approximately. Maryland is a challenging place to age in place. So as someone is transitioning from independent living at home to living with caregivers at home, or aging into a assisted living community, and God forbid aging past an assisted living community, which many people don't, but aging past that and needing skilled nursing, okay? It's critical to know the levels of care that this person needs in relation to how much money they may have to be able to pay for assisted living, because assisted living in Maryland, and we're making very broad brushstrokes here, very broad brushstrokes. There are some fine brushstrokes, but we're making some very broad ones. Assisted living basically is private pay in Maryland. So until we move past a level 3 assisted living, which is the highest level of care in assisted living, until we move past there into skilled nursing, with some exceptions, very minimum exceptions, that is going to be private pay up to that point. Medicaid will pay beyond that level 3 assisted living if someone is in skilled nursing and is otherwise qualified for it and is spent down for it. But Maryland is largely a private pay state. So where am I going with all of that? We have to juxtapose the assets that a person has to pay for long-term care and always keep in mind the level of care for those that are challenged with this issue of how to pay for assisted living. And some of you are challenged with this, some of you are not, and you are very blessed if you do not have to worry about this issue. But life care managers and being able to get that level of assessment at a critical time, that is an important tool for you to walk away from, that you should always remember these kinds of tools are available to you. Now, as we start to get towards the latter part of the presentation, I'm going to give you this very general information about how I would look at elder law. For a married couple, we always want to look at creating a foundational approach. So here's a person, or a couple, I should say, that comes in to see an elder law attorney. What do we want to do? Well, we want to have a full-scale estate plan, and we want to make sure we've planned for death with wills or trusts, and we also want to make sure we have possibly the most important document in estate planning and elder law for sure, and that is the financial power of attorney. We want to build maximum flexibility depending on the circumstances. The circumstances may not be appropriate for that maximum flexibility, but that's what we need as a foundational thing. If we do nothing else but address the cost of care, do full educational counseling, and build maximum flexibility, that couple is ready for the future as far as being able to maneuver within the world of changing circumstances, changing laws, changing healthcare, and the cost of care for elder care. Now, in some cases with a married couple, it's going to be appropriate to transfer assets, to say that the ill spouse, that person who has got a progressive illness, they should not really retain all of the non-retirement assets. So there could come a time when it makes sense to move those assets out of that person's name for various reasons and create a certain type of spousal estate plan that will maximize asset protection. Number 3, it could be a pre-crisis situation where there's really nothing on the front burner, nothing that's really that concerning, but we're getting older. And this particular couple wants to know, how do we think about our divestment of assets? We want to divest our home and make sure Medicaid can never place a lien against that home, or that Medicaid can never recover in a state recovery against that home. That's our number 1 goal. See, everything is goal driven. But we have a pre-crisis concern, and we want to get ahead of this issue by getting our planning in place. Or there could be a crisis plan. This could be a Medicaid spousal spend down of the assets. That's a mouthful, meaning that the properly informed and represented spousal couple, that couple, the well spouse can preserve as many assets as possible as allowed under the federal law. Again, if we have the maximum flexibility that we can reasonably put in to the financial powers of attorney, that spouse can do this privately without asking a court to be able to do it. Now, for an unmarried person, we have the same issue. Whether it's that person coming in to talk to an elder law attorney themselves, or they're coming in with their children in some circumstances, we are doing the same thing right from the get-go. We're building maximum flexibility, addressing the cost of care, and having counseling about everything involved with their concerns and anxieties and fears. Once that person has that foundational flexibility, look at number 2, and this is the similar thing to what we saw with a couple. One of the persons on the webinar this morning asked a wonderful question about whether an agent under a power of attorney could divest assets for us in the event that we are incapacitated. Well, here we have a pre-crisis situation where we could divest assets if the client is well and can think through their own issues, or they are slightly impaired, let's say, but they're not going to have a long-term care skilled nursing need for at least 5 years. Their agent could help divest assets and get those assets out of the name of that person in various ways that might make sense, either outright or in further trust under a financial power of attorney, if it's broad enough. And then, as I mentioned earlier, with a single person, most people don't know that under the current law, it is possible to preserve about 50% more or less of the non-retirement assets if a person has to go into a skilled nursing home and is single. So the rule of halves basically says, if I'm single and I've got the proper counseling, I can get qualified for a long-term care nursing home. Medicaid will pay for it, Maryland will pay for it, but I can still save half of my assets. I'm going to stop right there for just a second and say, no one wants to live in a skilled nursing home. I just had a relative who passed away who lived in a skilled nursing home for the last year of their lives. And I met with someone the other day who had lived in a nursing home, a skilled nursing home, but had actually rehabilitated and was able to leave the nursing home, which was amazing. So none of us want to live in a skilled nursing facility, and we don't want anyone else to live in a skilled nursing facility. So that's why I would strongly encourage you to think about long-term care insurance, analyzing your current long-term care insurance policies, talking to your financial advisors and attorneys about alternatives to long-term care insurance, financial planning, maximizing income, trying to avoid, which I know all of us are trying to do that, avoid a placement in a long-term skilled nursing facility. But I do want to say at the same time, the persons who cared for my loved one in that skilled facility, I can't say enough good things about. And although I was the kind of person who could go several times a week to check on the loved one that has passed away, notwithstanding the fact that I was a good advocate and I did what I needed to do to advocate for this person, the nursing home staff, I cannot say enough good things about them and what they did and their care. So this is going to be situational, and you need to do your due diligence. But again, my thanks goes out to those dedicated, very dedicated professionals who took care of my loved one. And even though many of us are very nervous about a nursing home situation, and nursing homes have many times a very poor reputation, sometimes very deserved, there are skilled and very professional people who are dedicated to caring for our elderly and aging population. When we think about incapacity planning, as we start to wrap up, I've mentioned this several times, nothing could be more important than understanding financial powers of attorney. Most law firms do not emphasize this. Most law firms do not even review financial powers of attorney with their clients. At Elville & Associates, we spend an entire meeting reviewing powers of attorney and advanced directives, and I think this is mystifying to the broader estate planning community as to why we do that. But at the same time, the estate planning community will acknowledge that financial powers of attorney are arguably the most important documents in estate planning, and I will say absolutely, without a doubt, the most important document in incapacity and elder care planning. Of course, advanced medical directives are very important. All of these documents need to be in place to avoid guardianship, assure privacy, and the ability to do private strategy planning outside of a guardianship, which is very restrictive. The Maryland Power of Attorney form is not necessarily enough, so we want to layer that. I'm going to skip through these slides. We are going to layer that document with a general durable power of attorney so that the broader elder care powers can be properly structured. So remember, we don't want a financial power of attorney that is plain vanilla. Yes, Jeff?
Hey, Steve, sorry about that. One question related to that is, can a medical power of attorney execute a DNR if their loved ones cannot make that decision?
Excellent question. I'm going to say that the agent themselves, based on where I sit today, the agent themselves cannot do that. The agent can advocate and operate within the broad parameters of the advanced medical directive, but the do not resuscitate order, the actual, literal do not resuscitate order, does not live within the advanced medical directive, and as you may know, it is in the most form. So that general agent, that agent under the advanced directive, cannot sign a most form. Only a doctor or nurse practitioner can sign a most form. So my answer to that question is, I think the agent under the advanced directive, if they have been given broad flexibility powers under that advanced directive, I think they certainly can sit with the doctor or nurse practitioner and make changes that have to do with do not resuscitate, in my opinion, by directing the doctor or nurse practitioner to make that change.
Thank you, Steve. We do have a couple more, but let's go ahead and move on just for now, and we'll address those at the proper time.
We're going to move through this quickly, Jeff. I got a little bit entrenched in my initial remarks. The advanced medical directive, please consider customizing this. Please read Maryland healthcare decision law. If you don't have the time to do that, we're happy to send you some general information about it. We talked about the most form just now. We're going to skip past that. And as we wrap up, and we're getting ready to take some further questions, we encourage you to set a consultation if you have any concerns, anxiety, hopelessness, exhaustion, whatever it may be that you're dealing with regard to elder care. Remember that there is nothing to fear about these kinds of consultations. When you enter into a relationship like that, you're sharing confidential information. There is an attorney-client privilege. Attorney-client privilege attaches to that meeting. So there's really nothing to fear. We want to know some information about you, ideally. We want to see your current estate planning documents. We want to know if you have an advisory team in place. Do you have a financial advisor? Do you have a CPA? Do you have a life insurance professional? Do you need a life care manager referral? All of these things we want to know so that we can help you. And the wonderful questions today, and I think we have a couple more questions, are just wonderful. I mean, we are here to be resources to you. We have high-tech conference rooms here at Elville and Associates, either our Rockville office or 3 or 4 conference rooms here in Columbia, and we have an office in Annapolis. Let us be here for you. We do want to give you time to think, time to have epiphanies, and to educate yourself and decide based on the choices what direction to go in. But we want to be counselors, and we want to enter into a partnership with you to feel that you can feel like you are being supported at challenging times. So Jeff, I'm going to turn it back to you. And I guess the last thing I'll say is as we approach fall, I just want to thank everybody for your support of our webinar series. And Jeff, and as I mentioned earlier, the wonderful weather, I happened to be at Cracker Barrel down in the Delaware Beach area over the weekend, and I picked up, I was impressed, I was amazed at their fall, I don't usually go to Cracker Barrel, so I was really happy to go in there for the first time in quite a while. And they had an amazing fall collection and Christmas collection and Halloween collection of just fun things to look at. And Jeff, I picked up a fall seasonal gnome. It's a gnome, and for anybody that comes in the office, I think you'll get a big laugh at our gnome that is setting out in front of the office. So just look for our holiday gnome, and again, try to just bring a little bit of a sense of humor to this very serious discussion. So I thank all of you, and Jeff, I'm turning it back to you.
Well, thanks, Steve. Funny you mentioned Cracker Barrel. They're actually rebranding Cracker Barrel completely, I've heard. So sometime in the next year or so, all those restaurants that we're used to going to that are Cracker Barrels are going to look a lot different, apparently. So, so I've always enjoyed going there myself.
Well, I hope they don't take away my fun gadgets, Jeff.
Yes, exactly. Those should stay. Well, thanks for a great presentation, Steve. As always, this is a great time to get any final questions that you have in to Steve. And so I'll pose the couple that we have here for now. Looks like we have a few now. First is, Steve, do you provide planning and consultation services for DC residents?
Good question. We are barred in DC by way of one or more attorneys at our firm that's barred in DC. DC Medicaid is a little bit different than Maryland. And so our of counsel attorney, Morris Klein, would be our DC counsel. So the answer is yes, through our DC of counsel attorney, Morris Klein, our good friend.
Next question is, could you briefly address the recent IRS change relative to trusts being beneficiaries of, for example, an IRA?
Thank you for asking that question. So in 2019, President Trump signed the Secure Act and it became law in 2020. Both sides of Congress supported this bill, and it's been largely amended twice so that we have the Secure 2.0. So what that means is that traditional notions of when we pass away, we, the persons who have a 401k or an IRA, a retirement plan, and when we leave that inherited IRA to our children or other beneficiaries, if we have healthy children, and I'm using a very broad term, then those children are not exempt. Those children are not exempt. So that means that they have to empty. They have to take that inherited IRA and empty it in 10 years. They have to pay all the tax in 10 years. And you and I know what this means. This means that Uncle Sam is going to tax trillions of dollars of IRA money in a very short period of time. So that's what this is all about. Now, there are 5 exemptions, or the 5 exceptions. So it's people that are under 21 years of age, meaning as defined by the Secure Act, someone who's under 21 is exempt. They can stretch out the IRA distributions for their lifetime. Starting when they receive the inherited IRA, they can stretch it out and tax defer it well into their 80s under the rules, except that when that person becomes 21, they now only have 10 years. So under that rule, the minor child being under 21, that's defined by the Secure Act, is exempt. However, when they turn 21, then the 10-year rule kicks in. But prior to 21, they are treated as if they could have stretched it out forever. So that's the first exception. Spouses are exempt, so we're not going to worry about that right now, even though that's an issue. That's a good issue. People who are less than 10 years younger than the plan participant, those people are exempt, such as siblings that might be older than you, siblings that are less than 10 years younger than you otherwise. So those people are exempt. Chronically ill people are exempt, and that's a tough definition to meet. And then we have disabled people, people with special needs and so forth, as much more clearly defined. Someone who is on SSI, someone who's on SSDI. So what we have to deal with here in elder law is understanding, is the beneficiary an exempt person under the Secure Act? And so we simply have to make sure that we're maximizing that. A good example would be when you leave an IRA to a special needs trust. We want to make sure that that supplemental special needs trust, so to speak, is exempt for Secure Act purposes. The person is exempt, but we want to make sure their trust is exempt as well. And so this is where we're really going to maximize the IRA money for a person who is exempt. For people who are not exempt, if you're doing estate planning and you have a child or two children who are non-exempt, they are healthy individuals, then we have a whole different set of issues. How do we want to basically approach the Secure Act? Do we want to do anything that's going to offset the acceleration of income tax? This child is going to pay a lot of income tax in a very quick period of time, and they otherwise could have really stretched out those assets. So are we going to do Roth conversions in very close consultation with our financial advisors? Are we going to do life insurance? Are we going to buy life insurance in a certain way to offset the cost? Are we going to do charitable planning? Because now the Secure Act is basically blowing up our retirement plan assets as we leave them to our children. So that's a broad but brief overview of what we're dealing with the Secure Act of 2020.
Okay, thank you, Stephen. Last question for now. can you provide counsel for a MAPT for a client who is a resident in California?
Good question. We would certainly work with California counsel on this. We probably would just be ancillary counsel to something like this. We could get the process started. We could ride along with the planning. We could even possibly create a trust with the tools that we have available to us, but we certainly would not attempt to practice law or attempt to settle a trust in California for a California resident without California counsel. So most likely, we would direct the referral to California counsel, and we would either let them take over the representation 100%, or we would simply co-counsel with them. That's a great question.
Great, thank you, Steve. So as always, I will be sending out what I think is a comprehensive email of some of the information that was covered today. I'll send out the video link and the slides again, information about the MOLS form that Steve referenced several times, and also want to mention Andre Lingham, who is a wonderful friend of the firm here and many in the community. He runs a nonprofit called the Center for Elder Justice and Education, and it really is a great resource for our community, focusing on preventing and addressing financial and other exploitation of older adults. Been a great presenter for us in the past, presenting at our client event again in November, on November 9th. So I'm going to send you some information about that. He is a great resource for anything related to what I just mentioned. So great guy. I'll send that information to you. As far as our presentations coming up, I'll send you the full list in my follow-up email. We have several virtual presentations about the essentials of estate planning and elder law, including an evening presentation with our friend Mark Timmick, Timmick Financial, and also guest presenters from the Wendy Slaughter team, realtors and seniors real estate specialists, about unlocking your value in your home, the impact of condition on sale price. So new presentation coming up with some great friends to the firm as well. If we can be a resource to you in any way, Steve or me or anybody else here, please reach out to me and Steve, and we'll go ahead and certainly point you in the right direction and talk about what we can do to help you, including the all-important elder law consultation. So with that, have a great day. Thanks for your interest in our webinar series, and we'll see you again soon. Take care, everybody.